University of Santo Tomas Criminal Law Review Pre-Week Notes of 2016 Part 6. Crimes Against Civil Status. A contracted a second marriage while having a subsequent and valid first marriage. The first marriage was declared void ab initio. Subsequently, A was charged with the crime of bigamy. A contends that the information on bigamy must be quashed on the ground that there was a declaration of nullity of the previous marriage prior to the filing of the action. Is the contention of A correct? The answer: no. The contention of A is wrong. It has been clarified in the Family Code and has been held in a number of cases that a judicial declaration of nullity is required before a valid subsequent marriage can be contracted. What makes a person criminally liable for bigamy is when he contracts a second or subsequent marriage during the subsistence of a valid marriage. Parties to the marriage should not be permitted to judge for themselves its nullity. Also, the declaration of nullity of marriage before the filing of the complaint against him is not a valid reason to quash an information. Well settled is the rule that criminal culpability attaches to the offender upon the commission of the offense, and from that instant, liability appends to him until extinguished as provided by law, that the time of filing of the criminal complaint or information is material only for determining prescription. That case is in People versus Udtuhan, JR number 191566, July 17, 2013. Another case here: Vitangcol married Alice Eduardo and begot 3 children. After some time, Alice began hearing rumors that her husband was previously married to another woman named Gina Gairlan. Such marriage was supported by a marriage contract registered with the NSO. This prompted Alice to file a criminal complaint for bigamy against Vitangcol. In his defense, Vitangcol alleges that he already revealed to Alice that he had a fake marriage with his college girlfriend, Gina, and that there is a certification from the Office of the Civil Registrar that there is no record of the marriage license issued to Vitangcol and his first wife, Gina, which makes his first marriage as void. Is Vitangcol liable for the crime of bigamy? The answer: yes, Vitangcol is liable for the crime of bigamy. Bigamy consists of the following elements: 1. That the offender has been legally married. 2. That the first marriage had not been yet legally dissolved, or in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the Civil Code. 3. That he contracts a second or subsequent marriage. 4. That the second or subsequent marriage has all the essential requisites for validity. In this case, all the elements of bigamy are present. Since Vitangcol was still legally married to Gina when he married Alice, his defense of certification from the Office of the Civil Registrar, implying that there is no record of the marriage license issued to Vitangcol and his first wife Gina, will not lie, since marriage are not dissolved through mere certifications by the Civil Registrar. Hence, Vitangcol is still considered to be legally married to Gina when he married Alice and is not exculpated from the bigamy charge. That case is found in Vitangcol versus People, GR number 207406, January 13, 2016. Maine was validly married to Lico on June 1, 2015. Lico, however, died a month after the celebration of their marriage. 3 months after the death of her husband, Maine found another love of her life in the name of Darnay. They eventually fell in love with each other. Darnay married Maine on October 3, 2015. Is Maine liable for any crime? The answer, no. RA 10655, March 13, 2015, decriminalized the act of premature marriage. Article 1 of the said law provides that without prejudice to the provisions of the Family Code on paternity and filiation. Article 351 of Act number 3815, or otherwise known as the Revised Penal Code, punishing the crime of premature marriage committed by a woman, is hereby repealed. Another topic here is the crimes against honor. True or false? In the crime of libel, truth is an absolute defense that is asked in 2010 bar exam. The answer, false. Because Article 361 of the Revised Penal Code provides that proof of truth shall be admissible in libel cases only if the same imputes a crime or is made against a public officer with respects to facts related to the discharge of their official duties, and moreover must have been published with good motives for justifiable ends. Hence, truth as a defense on its own is not enough. X was charged with the crime of libel. In his defense, he contended that he should not be liable for the crime of libel because there is no malice in fact proven by the prosecution, since he is merely a responding urban poor leader acting as counsel, defending a member of the association under threat of ejectment from her dwelling place, and thus should be considered as privileged communication. X also contends that there is no proper publication since the libelous remarks were only made in private correspondence. Are the contentions of X correct? The answer, X is criminally liable for the crime of libel. When the imputation is defamatory, the prosecution need not prove malice on the part of X, for the law already presumes that his imputation is malicious. There is publication when the same letter was furnished to all those concerned. A written letter containing libelous matter cannot be classified as privilege when it is published and circulated among the public. That is Buates versus People, GR number 142509, January 24, 2006. Another case, Alexis filed an action for damages against the libel and defamatory against Alejandro on account of a published letter containing the following. This is to notify you and your staff that one Alexis or Dodong C. Almendras, a brother, is not vested with any authority to liaison or transact any business with any department, office, or bureau, public or otherwise, that has bearing or relation with my office, mandates, or functions. Noteworthy to mention, perhaps, is the fact that Mr. Alexis Dodong C. Almendras, a renowned blackmailer, is a bitter rival in the just concluded election of 1995 who ran against the wishes of my father, the late Congressman Alejandro D. Almendras Sr. He has caused pain to the family when he filed cases against us, his brothers and sisters, and worst, against his own mother. I deem that his act of transacting business that affects my person and official functions is malicious in purpose, done with ill motive and part of a larger plan of harassment activities to perforce realize his egoistic and evil objectives. May I therefore request the assistance of your office in circulating the above information to concerned officials and secretariat employees of the House of Representatives. Alejandro, in his defense, insists that he has the legal, moral, or social duty to make the communication, or at least had an interest to protect, bound to insulate his office and his constituents from the dubious and mistrustful pursuits of his elder brother. Moreover, the letters were also not meant to be circulated or published. They were sent merely to warn the individuals of respondents' nefarious activities and made in good faith and without any actual malice. Is Alejandro guilty of libel? The answer, yes. Under Article 354, every defamatory imputation is presumed to be malicious, even if true, if no good intention and justifiable motive is shown. As an exception to the rule, the presumption of malice is done away with when the defamatory imputation qualifies as privileged communication. In order to qualify as privileged communication under Article 354, Number 1, the following requisites must concur. The person who made the communication had a legal, moral, or social duty to make the communication, or at least had an interest to protect with interest may either be his own or of the one to whom it is made. Number 2, the communication is addressed to an officer or a board or superior having some interest or duty in the matter, and who has the power to furnish the protection sought. Number 3, the statements in the communication are made in good faith and without malice. Alejandro's contention that he has the legal, moral, or social duty to make the communication cannot be countenanced because he failed to communicate the statements only to the person or persons who have some interest or duty in the matter alleged and who have the power to furnish the protection against by the author of the statement. A written letter containing libelous matter cannot be classified as privileged when it is published and circulated among the public. Next topic is the criminal negligence. What is the doctrine of last clear chance? The last clear chance doctrine states that the contributory negligence of the party injured will not defeat the action if it be shown that the accused might, by the exercise of reasonable care and prudence, have avoided the consequences of the negligence of the injured party. What is reckless imprudence? The reckless imprudence consists in voluntary, but without malice, doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. What is simple negligence? A simple negligence consists in the lack of precaution displayed in cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. Question here. Y, while alighting from his vehicle, was hit by X with his car. This caused Y to be thrown 4 meters away from his jeepney. X was charged with frustrated murder and convicted in the RTC of frustrated homicide. Upon appeal in the CA, the crime was modified to reckless imprudence resulting in serious physical injuries. X contends that he is not liable for such crime because he lacked of criminal intent, that he was not negligent in driving his pickup truck, and that the CA should have appreciated voluntary surrender as a mitigating circumstance in his favor. Is X contention correct? The answer, the contention of X is wrong. To constitute the offense of reckless driving, the act must be something more than a mere negligence in the operation of the motor vehicle, but a willful and wanton disregard of consequences is required. The fact that Y's body was thrown 4 meters away from his jeep shown that X was driving his pickups at a fast speed when he overtook the jeep of Y. The mitigating circumstance of voluntary surrender cannot be appreciated in his favor. Paragraph 5 of Article 365 Revised Penal Code expressly states that in the imposition of the penalties, the court shall exercise their sound discretion without regard to the rules prescribed in Article 64 of the Revised Penal Code. Mariano versus People, JR number 178145, July 7, 2014. Another scenario here, X, while descending from a curved path, collided with a motorcycle, killing Y, one of its passengers, and causing serious physical injuries to the two other victims. The body of Y was loaded to the vehicle of X, but the latter's engine would not start. Thus, the body was loaded in a different vehicle. The jack of X was used to extricate the body of Y from being pinned under the vehicle of X. X, in his defense, claimed that it was not his fault that the tricycle swerved in his direction. X was charged with reckless imprudence resulting to homicide with double serious physical injuries and damage to property under Article 365 in relation to Article 263 of the Revised Penal Code, with the aggravating circumstance that accused failed to lend on the spot to the injured party such help that what in his hands to give. Should the court appreciate the alleged aggravating circumstances? The answer, no. The aggravating circumstance that accused failed to lend on the spot to the injured party such help that was in his hands to give should not be appreciated. Verily, it is the inexcusable lack of precaution or conscious indifference to the consequences of the conduct which supplies the criminal intent in Article 365. The limiting element in the last paragraph of Article 365 of the Revised Penal Code, which imposes the penalty next higher in degree upon the offender who fails to lend on the spot to the injured parties such help as may be in his hands to give. According to case law, A is dependent on the means in the hands of the offender. Example, the type of the degree of assistance that he or she at the time and the place of incident is capable of giving. B requires adequate proof. X was able to supply the help according to the extent of capabilities. That is Gonzaga versus People, JR number 195671, January 29, 2015. For our next topic, it is a special penal laws. To start with, Anti-Graft and Corrupt Practices Act. Cite an example of an act which constitute as graft and corrupt practices and state the elements constituting the crime. Example here is in Section 3E, causing any undue injury to any part including the government or giving any private party any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions through manifest partially, evident bad faith, or gross inexcusable negligence. The elements are as follows. Number 1, the offender is public officer who performs official, administrative, or judicial functions. Number 2, that said official acted with manifest partiality, evident bad faith, or gross inexcusable negligence. Number 3, the said official caused any undue injury to any party, including the government, or gave any private unwarranted benefits, advantage, or preference in the discharge of his official functions. Another question, how many crimes are mentioned in this example? There are 2 crimes mentioned. The Supreme Court said that the law used disjunctive word or. Hence, two crimes are mentioned under Section 3E. Number 1, causing any undue injury to any party. Number 2, giving any private party any unwarranted benefit, advantage, or preference. Another question here. Attorney David Luste, president of the Eastern Summer chapter of the IBP, sent a letter to the Office of the Ombudsman praying for an investigation into the alleged transfer of then Mayor Francisco Adalim, an accused in criminal case for murder, from the provincial jail of Eastern Samar to the residence of then Governor Ruperto A. Ambil Jr. The NBI filed a report recommending the filing of criminal charges against Governor Ambil Jr. for violation of Section 3E of Republic Act Number 3019, or the Anti-Graft and Corrupt Practices Act as amended. It was alleged that the detention prisoner Mayor Adalim was released from jail and allowed to stay at Ambil's residence for a period of 85 days without any court order authorizing such a transfer. Thus, Ambil, in the performance of his official functions, had given unwarranted benefits and advantages to detainee Mayor Francisco Adalim to the prejudice of the government. Ambil admitted the allegations in the information. They argued, however, that Adalim's transfer has justified considering the imminent threats upon his person and the dangers posed by his detention at the provincial jail. This threat was that of Akyatan's gesture of raising a close fist at Adalim. Can Ambil Jr. be held liable? The answer, yes. Without a court order, Ambil and Apilado transferred Adalim and detained him in a place other than the provincial jail. The latter was housed in much more comfortable quarters, provided better nourishment, was free to move about the house and watch television. Ambil readily extended these benefits to Adalim on the mere representation of his lawyers that the mayor's life would be put in danger inside the provincial jail. As the Sandigan Bayan ruled, however, Ambil and Apilado were unable to establish the existence of any risk on Adalim's safety. Even if we treat Akyatan's gesture of raising a close fist at Adalim's as a threat of aggression, the same would still not constitute a special and compelling reason to warrant Adalim's detention outside the provincial jail. One, there were nipa huts within the perimeter fence of the jail, which could have been used to separate Adalim's from the rest of the prisoners, which the isolation cell was undergoing repair. Anyhow, such repair could not have exceeded at 85 days that Adalim stayed in Ambil. More importantly, even if Adalim could have proven the presence of an imminent peril on his person to Ambil, a court order was still indispensable for his transfer. That is Ambil Jr. versus Sandigan Bayan, JR number 175457, July 6, 2011. Here's another question here. This was asked in 1999 bar exam. Who are public officers? The answer, public officers are persons who, by direct provision of the law, popular election, or appointment by competent authority, take part in the performance of public functions in the government of the Philippines or perform in said government or in any of its branches public duties as an employee, agent, or subordinate official of any rank or class. That is defined in Article 203 of the Revised Penal Code. Another question from 1999 bar exam. What preconditions are necessary to be met or satisfied before preventive suspension may be ordered? The answer: the preconditions necessary to be met or satisfied before a suspension may be ordered are: number one, there must be proper notice requiring the accused to show cause at a specific date of hearing why he should not be ordered suspended from office pursuant to RA 3019 as amended. Number two, there must be a determination of a valid information against the accused that warrants his suspension. So number one, there must be a proper notice requiring the accused to show. And number two, there must be a determination of a valid information against the accused. Another question: an administrative case and a violation of RA 3019 was filed against the public officer. Insofar as the violation of RA 3019 is concerned, the public officer was placed under preventive suspension for 90 days, and then thereafter, the Office of the Ombudsman placed him again under preventive suspension on account of the administrative case. The public officer contended that since he has already been placed under preventive suspension in RA 3019 case, he can no longer be placed under preventive suspension in the administrative case. Is the contention of the public officer correct? The answer: no. The two are separate and distinct violation of laws. The public officer may be placed under preventive suspension twice. Here's another question from the bar, 2010 bar exam. May a public officer charged under Section 3B of Republic Act Number 3019 or directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself of for any other person in connection with any contract or transaction between the government and any other party wherein the public officer in his official capacity has to intervene under the law. Also be simultaneously or successively charged with direct bribery under Article 210 of the Revised Penal Code. Explain. The answer: yes, a public officer charges under Section 3B of RA 3019 Anti-Graft and Corrupt Practices Act may also be charged simultaneously or successively for the crime of direct bribery under Article 210 of the Revised Penal Code because two crimes are essentially different and are penalized under distinct legal. Violation of Section B of RA 3019 is a malum prohibitum. The crime under Article 210 of the Code is a malum in se. Another question. During the audit report conducted by the COA Regional Office, it was found out that the accused herein, Venancio Nava, succeeded in persuading his 7 school division superintendents to use the allotment for the purchase of science laboratory tools and devices for the calendar year of 1990. However, the said money was supposed to be used for the improvement of the school facilities, and it is required that in buying school materials, it must undergo an effective public bidding. Nava persuaded his school division superintendents to ignore the circular requiring public bidding as allegedly time was of the essence in making the purchases, and if not done before the calendar year 1990, the funds allotted were revert back to the general fund. Furthermore, the COA found that the contract that was entered into by Nava sellers exceeded the prevailing market price ranging from 56% to 1,175% based on the mathematical computation done by the COA audit team. The loss of the government was said to be in the amount of 380,013 pesos and 60 cents. Nava was charged, therefore, with the violation of Section 3G of RA number 3019 for entering on behalf of the government in any contract or transaction manifestly and grossly disadvantageous to the same, whether or not the public officer profited or will profit thereby. Is the suit vested with merit? The answer, yes, the suit is with merit. In order to be liable for such, the following elements must be present. Number 1, the accused is a public officer. Number 2, the public officer entered into a contract or transaction on behalf of the government. Number 3, the contract or transaction was grossly and manifestly disadvantageous to the government. In this case, Nava is a public officer who approved the transactions on behalf of the government, which thereby suffered a substantial loss. The discrepancies between the prices of the SLTDs and the samples purchased by the COA audit team clearly establish such undue injury. Indeed, the discrepancy was grossly and manifestly disadvantageous to the government. In this case, there is a clear showing that all the elements of the offense are present. Thus, there can be no other conclusion other than conviction. That is Nava versus Sandigan Bayan, JR number 160211, August 28, 2006. Another question. The mayor of LGU, along with several local government officials, through their official duties, purchased a various occasions through personal canvas from Zaro Trading, a total of 142,612 pieces of walis ting-ting of either 25 per piece or 15 per piece. The said purchases were made without the required public bidding and were overpriced. Can the local government officials be held liable for entering a contract which is disadvantageous to the government on account of failure to conduct public bidding and alleged overprice based on the unsigned quotation from the walis ting-ting supplier alone? The answer, no. Given the factual milieu of this case, the subject contracts would be grossly and manifestly disadvantageous to the government if characterized by an overpriced procurement. However, the gross and manifest disadvantage to the government was not sufficiently shown because the conclusion of the overpricing was erroneous since it was not also adequately proven. In finding that the walis ting-ting purchase conducts were grossly and manifestly disadvantageous to the government, the Sandigan Bayan replied on COA's finding of overpricing, which was in turn based on the special audit team's report. Notably, however, the evidence of the prosecution did not include a signed price quotation from the walis ting-ting suppliers of Parañaque City. Effectively, the prosecution was unable to demonstrate the requisite burden of proof in order to overcome the presumption of innocence in favor of the petitioner. That is the case of Kaunan versus People, JR number 182001-04. September 2, 2009. Another question. Dr. Chow, a government doctor, failed to submit his daily time record or the DTR from January to March 2000 and did not get approval of his sick leave application for April because of evidence that he was actually moonlighting elsewhere. Thus, the medical director caused the withholding of his salary for the periods in question until the submitted until he submitted his DTR in May 2000. Can Dr. Chow prosecuted the medical director for causing him undue injury in violation of anti-graft and corrupt practices? The answer, no, since Dr. Chow brought it upon himself, having failed to submit the required DTRs. Okay. Another special law here. This is the Anti-Violence Against Women and Their Children Act, or otherwise known as RA 9262. Okay, here's question. What are the three phases of the battered woman syndrome? Okay, the three phases of the battered woman syndrome is number 1, the tension building phase. Number 2, the acute battering incident. Number 3, the tranquil or loving or non-violent phase. That is found in People versus Hinosa, JR number 135981, January 15, 2004. Here's an illustration. BB and AA had a relationship when the latter was still raising his first child born, CCC, from a previous relationship. During the relationship with BBB, AAA bore 2 more children, namely DDD and EEE. To legalize the relationship, BBB and AAA married in civil rights, and thereafter the birth certificates of the children, including CCCs, was amended to change their civil status to be legitimated by virtue of the said marriage. However, there were fights and arguments which caused them to have strained relationship that led them to filing of a case. Pending the court's deliberation of the instant case, BBB filed a manifestation and motion to render judgment based on a memorandum of agreement. BBB alleges that on July 29, 2013, he and AAA had entered into a compromise anent custody, exercise of parental authority over and support of DDD and EEE. Is the case a proper subject of a compromise agreement? The answer: the instant petition is not a proper subject of a compromise agreement. The law explicitly prohibits compromise on any act constituting the crime of violence against women. Thus, in Garcia versus Drilon, the court declared that violence, however, is not a subject for compromise. Quote, a process which involves parties mediating the issue of violence implies that a victim is somehow at fault. Of quote. Note, AAA filed her application for a temporary protection order, or the TPO, and a permanent protection order, PPO, as an independent action and not as an incidental relief paid for a criminal suit. The instant petition cannot be taken outside the ambit of cases falling under the provisions of RA 9262. Perforce, the prohibition against subjecting the instant petition to compromise applies. BBB versus AAA, JR number 193225, February 9, 2015. Here's a question here. Sharika Marigo Tan and Stephen Tan were married. Barely 6 years after the marriage, Go Tan filed a petition with prayer for the issuance of a temporary protective order against Tan and his parents-in-law before the RTC. She alleged that Tan, in conspiracy with her parents-in-law, were causing verbal, psychological, and economic abuse upon her. Can the parents-in-law be considered as conspirators and be included in the petition for issuance of a TPO? The answer: yes. Section 3 of RA 9262 provides that the offender must be related or connected to the victim by marriage, former marriage, or a sexual or dating relationship. It does not preclude the application of the principle of conspiracy under RPC. That is the case of Go Tan versus Tan, JR number 168852, September 30, 2008. Another question. Del Socorro and Van Welsem got married in 1990 in Holland. They were blessed with a son. However, in 1995, their marriage bond ended by virtue of a divorce decree issued by the appropriate court of Holland. Van Welsem made a promise to provide monthly support for their son. Del Socorro and their son went back to the Philippines. Since the arrival of Del Socorro and their son of the Philippines, Van Welsem never gave support to their son. Consequently, Van Welsem came to the Philippines and remarried. All of the parties are presently living in Cebu City. Thereafter, Del Socorro sent a letter demanding support to Van Welsem. Is Van Welsem liable under RA 9262? The answer, yes. Van Welsem may be made liable under Section 5E and I of RA number 9262. The deprivation of or denial of financial support to the child is considered an act of violence against women and children. That is the case of Del Socorro versus Van Welsem, JR number 193707, December 10, 2014. Note in Republic versus Yahon, GR number 201043, June 16, 2014, the trial court directed Armed Forces of the Philippines Finance Center to automatically deduct a percentage from the retirement benefits of Sergeant Charles Yahon, and to give the same directly to his wife, Daisy Yahon, as spousal support in accordance of the permanent protection order issued for his violation of the Anti-Violence Against Women and Their Children Act of 2004. Despite the provision of the exemption of funds provided in PD number 1638, the court held that Section 8G of RA 9262, being a latter enactment, should be construed as laying down an exception to the general rule that retirement benefits are exempt from execution. Here's another special law. Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act. That is RA 7610. Here's a question from 2005 bar exam. On July 1, 2004, Jet Matulis, a pedophile, gave 1,000 pesos to Shirley, an orphan and a prostitute, and brought her to a motel. He inserted a rusty and oversized vibrator in her vagina with such force that she bled profusely. Jet panicked and fled. Shirley was brought to the hospital and died a few days later because of shock caused by hemorrhage. If Shirley were a minor when she died, what are the liability of Jet Matulis? The answer, the crimes of homicide and child abuse in violation of RA 7610, or the Special Protection of Children Against Abuse, Exploitation, Discrimination, and for other purposes, are committed by Jet Matulis, provided Shirley is not less than 12 years old. If Shirley was less than 12 years old, then the crime committed by Matulis is rape through sexual assault with homicide, a special complex crime under Article 266B of the Revised Penal Code. Another question here for the RA 7610. Bungalon was charged for the crime of child abuse under Section 10A of RA 7610. Bungalon allegedly physically abused and or maltreated Jason, 12 years old, with his palm hitting the latter at his back and by slapping said minor, hitting his left cheek and uttering derogatory remarks to the latter's family. On his part, Bungalon denied having physically abused or maltreated Jason but only confronted him when the latter threw stones at her daughters, calling them as Kimi, and for burning one of his daughter's hair. Did Bungalon acts amounted to child abuse under RA 7610? The answer, no. When Bungalon struck and slapped Jason, he did not do so with the intention to debase the child's intrinsic worth and dignity or to humiliate or embarrass him. Rather, Bungalon did so at the spur of the moment and in anger, which only indicated his being overwhelmed by his fatherly concern for the personal safety of his own minor daughter. Not every instance of laying of hands on a child constitutes the crime of child abuse under Republic Act No. 7610. The court explained that a person can only be punished for child abuse when there's an intention to debase, degrade, or demean the intrinsic worth and dignity of the child as a human being. That is People versus Bungalon, JR number 169533, March 20, 2013. Here's another special law, the Juvenile Justice and Welfare Act. What are the status offenses? The status offenses is any conduct not considered an offense or not penalized if committed by an adult, shall not be considered an offense, and shall not be punished if committed by a child. That is the status offenses. Here's a 2013 bar exam question. Michael was 17 years old when he was charged of violation of Section 5 of RA 9165 or illegal sale of prohibited drugs. By the time he was convicted and sentenced, he was already 21 years old. The court sentenced him to suffer an indeterminate penalty of imprisonment of 6 years and 1 day of prison mayor as a minimum to 17 years and 4 months of reclusion temporal as maximum and a fine of 50,000 pesos. Michael applied for probation, but his application was denied because the probation law does not apply to drug offenders under RA 9165. Michael then sought the suspension of his sentence under RA 9344 or the Juvenile Justice and Youth Welfare Code. Can Michael avail of the suspension of his sentence provided under this law? The answer: the benefits of a suspended sentence can no longer apply to Michael. The suspension of sentence lasts only until as provided for by the law. The offender reaches the maximum age and thus could no longer be considered a child for purposes of applying RA 9344. However, he shall be entitled to the right of restoration, rehabilitation, and reintegration in accordance with the law to give him the chance to live a normal life and become a productive member of the community. Accordingly, Michael may be confined in an agricultural camp and other training facility in accordance with Section 51 of RA 9344, and that is in the case of People versus Sarsha, JR number 169641, September 10, 2009. Another question, can the provision of RA 9344 be given retroactive application? The answer, yes. Under Section 68 of RA 9344, Persons who are already convicted or are serving sentence but who were minors at the time of the commission of the crime shall be given retroactive application of the law. Thus, Section 38 of RA 9344, providing for a suspended sentence, apply even to child in conflict with the law who has committed a heinous crime? The answer, yes. According to the Supreme Court, such provision of RA 9344 does not distinguish as to the nature of the crime committed by the offender. Therefore, taking into consideration the rule in statutory construction that when the law does not distinguish, neither should the court distinguish. That is People versus Sarsha, JR number 169641, September 10, 2009. Note, the ruling of People versus Sarsha was reiterated in People versus Mantalaba, where the Supreme Court held that while Section 38 of RA 9344 provides that suspension of sentence can still be applied even if the child in conflict with the law is already 18 years of age or more at the time of the pronouncement of his guilt or of his or her guilt. Section 40 of the same law limits the said suspension of sentence until the child reaches the maximum age of 21. In finding the guilt beyond reasonable doubt of the appellant for violation of Section 5 of RA 9165, the RTC imposed the penalty of reclusion perpetua as mandated in Section 98 of the same law. The violation of Section 5 of RA 9165 merits the penalty of life imprisonment to death. However, in Section 98, it is provided that where the offender is a minor, the penalty for acts punishable by life imprisonment to death provided in the same law shall be reclusion perpetua to death. Basically, this means that the penalty can now be graduated as it has adopted the technical nomenclature of penalties provided for in the revised penal code. That is People versus Mantalaba, JR number 186227, July 10, 2011. Here's another special law. Human Security Act of 2007, or RA 9372. Here's a scenario. A bus full of children from the province went to Manila to have an excursion. Before the children were able to alight from the bus, here comes X in full battle gear with all kinds of guns and ammunitions, and at gunpoint, he told the conductor to open the bus. X hostage the children. Thereafter, X posted cartulinas on the glass windows of the bus. These cartulinas contained his demands to the government. Later, after 12 hours of negotiation, X gave in, and so X was arrested and was charged based on a valid complaint with violation of RA 9372. He was, however, acquitted. Can the state still prosecute X for the crime of serious illegal detention and for violation of RA 1059 for having in his possession various unlicensed firearms? The answer, no, because under Section 49 of RA 9372, it is provided that when a person has been prosecuted under the provision of this RA 9372 upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for any offense or felony which is necessarily included in the offense charge under RA 9372. Here's another special law, Anti-Trafficking in Persons Act. This was asked in 2014 bar exam. Loco advertised on the internet that he was looking for commercial models for a TV advertisement. Aganda, a 16-year-old beauty, applied for the project. Loco offered her a contract which Ganda signed. She was asked to report to an address which turned out to be a high-end brothel. Ganda became one of its most featured attractions. What is Loco's liability, if any, and what effect would Ganda's minority have on Loco's liability? The answer: Loco is liable of the crime of trafficking in persons under RA 9208. He recruited, offered, and hired Ganda by means of fraud or deception for the purpose of exploitation or prostitution by means of deceit. Example, in the guise of making her a commercial model. Loco recruited Ganda for the purpose of prostitution. And Ganda's minority is a qualifying circumstance. Under Section 6 of RA 9208, when the trafficked person is a child, the crime committed is qualified trafficking in persons penalized by life imprisonment. Here's another special law, the anti-fencing law. It is asked in 2000 bar exam, true or false? In a prosecution for fencing under PD 1612, it is a complete defense for the accused to prove that he had no knowledge that the goods or articles found in his possession had been the subject of robbery. The answer: false. Fencing is committed if the accused should have known that the goods or articles had been the subject of theft or robbery. Mere possession of the stolen goods gives rise to the prima facie presumption of fencing. Another question from 2010 bar exam. Arlene is engaged in the buy and sell of used garments, more popularly known as ukay-ukay. Among the items found by the police in a raid of her store in Baguio City were brand new Louis Farad Sears. Arlene was charged with fencing. Will the charge prosper? Why or why not? The answer: no. A charge of fencing will not prosper. Fencing is committed when a person with intent to gain for himself or for another deals in any manner with an article of value which he knows or should be known to him to have been deprived from proceeds of theft or robbery. Section 2 of PD 1612. Thus, for a charge of fencing to prosper, it must first be established that a theft or robbery of the article subject of the alleged fencing has been committed, which is a fact which is a wanting in his case. It should be noted that the suspect is engaged in the buy and sell of used garments which are in the nature of personal property. In civil law, possession of personal or movable property carries with it a prima facie presumption of ownership. The presumption of fencing arises only when the article or item involved is the subject of robbery or thievery. Section 5 of PD 1612. Here's another special law, the bouncing checks law, or known as BP 22. Who are the persons liable under BP 22? Number 1, any person who makes or draws and issues any checks, apply on account or for value, knowing at the time of issue that he does not have sufficient funds in or credit with the drawee bank for the payment of such check in full upon its presentment. Check is subsequently dishonored by the drawee bank for insufficiency of funds or credit, or would have been dishonored for the same reason had not the drawer, without any valid reason, ordered the bank to stop payment. Or, second, having sufficient funds in or credit with the drawee bank when he makes or draws and issues a check shall fail to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon, for which reason it is dishonored by the drawee bank. Here's the difference between BP22 and estafa. BP22 is a malum prohibitum. Estafa is a malum in se. The BP22 is a crime against public interest, while the estafa is a crime against property. In BP22, deceit is not required. In estafa, deceit is an element. In BP22, punishes the making or drawing or any check that is subsequently dishonored, whether issued in a payment of an obligation or to merely guarantee an obligation. It is the issuance of a check, not the non-payment of the obligation, which is punished. In estafa, the act of constituting the offense is postdating or issuing a check in payment of an obligation when the offender has no funds in the bank or his funds deposited therein were not sufficient to cover the amount of the check. The BP22 is violated if check is issued in payment of a pre-existing obligation, while in estafa, it is not violated if check is issued in payment of a pre-existing obligation. In BP22, damage is not required, but in estafa, damage is required. In BP22, drawer is given 5 banking days to make arrangement of a payment after receipt of notice of dishonor, while in estafa, drawee is given 3 days to make arrangement for payment after receipt of notice of dishonor. Here's a 2003 bar exam. A and B agreed to meet at the latter's house to discuss B's financial problems. On his way, one of A's car tires blew up. Before A left the meeting, he asked B to lend him money to buy a new spare tires. B had temporarily exhausted his bank deposits, leaving a zero balance. Anticipating, however, a replenishment of his account soon, B issued a dated check with which A negotiated for a new tire. When presented, the check bounced for lack of funds. The tire company filed a criminal case against A and B. What would be the criminal liability, if any, of each of the two accused? Explained. On the side of A, who negotiated the unfunded check of B in buying a new tire for his car, may only be prosecuted for estafa if he was aware at the time of such negotiation that the check has no sufficient funds in the drawee bank. Otherwise, he is not criminally liable. While B, who accommodated A with his check, may nevertheless be prosecuted under BP22 for having issued the check, knowing at the time of issuance that he has no funds in the bank, and that A will negotiate it to buy a new tire. Example for value. B may not be prosecuted for estafa because the facts indicated that he is not actuated by intent to defraud in issuing the check negotiated. Obviously, B issued the postdated check only to help A. Criminal intent or dolo is absent. Here's another question about the BP22. Campos obtained a loan from FWCC. In return, she issued a post-dated checks to FWCC as security for the loan. 14 of these checks were dishonored when presented to the bank. FWCC filed a case for violation of BP22. After her arraignment, she did not attend any of her hearings. Hence, she was tried in absentia. She was held guilty for violation of BP 22. She claims she did not receive any notice of dishonor. Further, she made subsequent arrangement for payments of the obligation to FWCC, which is tantamount to good faith. Is Campos liable for BP 22? The answer, yes, Campos is liable for BP 22. Section 2 of BP 22 creates a presumption of insufficiency of funds. When she made subsequent arrangement for payments of the obligation to FWCC, this statement was a confirmation that she actually received the required notice of dishonor from FWCC. That is found in the case of Campos versus People and FWCC, JR number 187401, September 17, 2014. Here's another question of BP 22. Castor used the checks given to him by Lim as payment for the delivery of printing materials. Later, asked Lim to stop payment as the printing materials were delivered too late. Later, Bade sent 2 demand letters to Lim and subsequently filed a complaint against Lim before the office of the prosecutor for violation of BP 22. After 1 month from receipt of the demand letters and after receiving the subpoena, Lim issued a replacement check and Bade was able to encash the said replacement check. 6 months after the payment of the bounced check, 2 informations were filed against Lim for violation of BP 22. Is he liable for violation of BP 22? The answer, no. The fact that the issuer of the check had already paid the value of the dishonored check after having received the subpoena should have forestalled the filing of the information in the court. That is, in the case of Lim versus People, JR number 190834, November 26, 2014. Here's another special law, the Anti-Carnapping Act as amended. A postal van containing mail matters including checks and treasury warrants was hijacked along a national highway by 10 men, 2 of whom were armed, and they used force, violence, and intimidation against 3 postal employees who were occupants of the van, resulting in the unlawful taking and asportation of the entire van and its contents. If you were the public prosecutor, would you charge the 10 men who hijacked the postal van with violation of Presidential Decree 532 or the otherwise known as Anti-Piracy and Anti-Highway Robbery Law of 1974? Explain your answer. The answer, no. If I were the public prosecutor, I would charge the 10 men of violation of 6539, the Anti-Carnapping Act. All the elements of carnapping are present. Number 1, there was actual taking of motor vehicle or the postal van. Number 2, the postal van belonged to another. Number 3, the taking was done with intent to gain. And number 4, the taking was done without consent of the owner and with force, violence, and intimidation against the 3 van employees who were occupants thereof. It is not, I repeat, it is not a highway robbery under PD 532 because there was no showing that the 10 men were a band of robbers organized for the purpose of committing robbery indiscriminately. What was shown is one isolated hijacking of postal van, hence it is a carnapping. Another question here, if you were the defense counsel, what are the elements of the crime of highway robbery that the prosecution should prove to sustain a conviction? The answer? The elements of highway robbery under PD 532 are: number 1, that there is unlawful taking of property of another. Number 2, that the said taking is with intent to gain. Number 3, that the said taking is done with violence against or intimidation of person or force upon things or other unlawful means. Number 4, that it was committed on any Philippine highway. Note, to sustain a conviction for highway robbery, the prosecution must prove that the accused were organized for the purpose of committing robbery indiscriminately. If the purpose is only a particular robbery, the crime is only robbery or robbery in band if there are at least 4 armed men. That is found in People versus Mendoza, JR number 104461, February 23, 1996, and also it is found in the case of Filotio Jr. versus Sandigan Bayan, JR number 79543, October 16, 1996. For our last topic, Revised Penal Code for this last special law. This is arson under RPC in relation to anti-arson law. The laws on arson is enforced today in PD 1613 and Article 320 as amended of the Revised Penal Code. Consequently, simple arson is governed by PD 1613 while destructive arson is governed by the Revised Penal Code. The nature of destructive arson is distinguished from simple arson by the degree of perversity or viciousness of the criminal offender. Here's another illustration. Macabando was found on the road holding a lead pipe and breaking bottles. That same night, a fire broke out in Macabando's house. Those living nearby tried to call for help and stop the fire, but were prevented by the owner of the house, who stood outside his house and fired several gunshots in the air. He also threatened to kill anyone who would try to put out the fire. In the process, other residential homes were also destroyed. The Bureau of Fire Protection conducted an investigation and the results revealed that the fire was intentionally started in the Macabando's home. The regional trial court found Macabando guilty beyond reasonable doubt of destructive arson, punishable under Article 320 of the Revised Penal Code. The CE affirmed the RTC judgment in tuto. Macabando contends that the crime committed is only simple arson. Is he correct? The answer, yes, Macabando is correct. Simple arson contemplates the malicious burning of public and private structures regardless of size, not punished under destructive arson. In this case, he burned his own house and other residential homes. There are 2 elements required for simple arson. First, intentional burning. And second, what is intentionally burned is an inhabited house or dwelling. The court held that both elements were sufficiently proven in court. All property destroyed in fire were his own house and several other inhabited homes. Based on the facts, the burning was clearly intentional. That is People versus Macabando, GR number 188708, July 31, 2013. Here's another question from 1989 bar exam. Diego and Pablo were both farmers residing in Barangay Damayan. On one occasion, Diego called Pablo to come down from his house in order to ask him why he got his Diego's plow without permission. One word led to another and Diego, in a fit of anger, sheathed his bolo and hacked Pablo to death. Pablo's 9-year-old son Mario, who was inside the house, saw the killing of his father. Afraid that he might also be killed by Diego, Mario covered himself with a blanket and hid in a corner of the house. To conceal the killing of Pablo, Diego brought Pablo's body inside the house and burned it. Mario was also burned to death. What crime or crimes did Diego commit? Diego committed 2 crimes. 1, homicide for the death of Pablo. 2, the special complex crime of arson with homicide as provided in PB 1613 for the burning of house and the death of Mario. The hacking of Pablo to death is homicide, the killing not being attended by any of the qualifying circumstances of murder. It was killing in the course of a quarrel. The burning of the house to conceal the killing of Pablo is a separate crime. Were it not for the death of Mario, this separate offense would have been arson. But inside the house, unknown to Diego, was Mario. The resulting crime is under PD number 1613 because the death resulted from the arson. If by reason or on the occasion of the arson, death results, the offense is the special complex crime of arson with homicide. That is Section 5 of PD 1613, which expressly repealed Article 320. And that is People versus Paterno, L-2665, March 6, 1950. Here's a note. If Diego knew that Mario was inside the house when he set it on fire, the crime committed instead of arson would be murder, with the use of fire as qualifying circumstance. And for our last case for this criminal law review, U, S, and T planned and conspired to burn the entire building owned by Barhish Over Corporation, their employer, who dismissed them from employment. On November 27, 2016, Tiger, son of Yu, learned about the said plan and convinced his father Yu to report the same to the authorities. For fear of law and karma, as he was about to take the 2016 bar examination in UST, however, Yu still joined S and T, and on the said agreed date, they proceed to the Barhis Over Corporation compound, able to pour 1,000 liters of gasoline all over the building, and when Yu was about to lit up the building, they were apprehended by police authorities who got a tip from Tiger about the said plan. What, if any, is or are the liability of U, S, and T? The answer: U, S, and T are liable for conspiracy to commit arson. Under Section 7 of PD 1613, conspiracy to commit arson shall be punished by prison major in its minimum period. It's the end of our criminal law review. I'd like to give credit to the academics committee who are making this criminal law pre-week notes of 2016. The academics committee is the managing editor. It is Robin Bernard M. Soriano. Executive committee, Erin Mariel Perez, Maria Nena Ruem A. Bonzol, John Ray E. Doctor, and the criminal law committee is committee head John Ray E. Doctor. Subject heads: Christine, Clarice, Angeline, and Dizon, Ana Francesca. The members: Agcaule Carlin May, Baluyot Mark Renzo, Belista Charisa, Carelio Jane Marie Bianca, Diaz Kimberly Joy, Diola Gail Ann, Isma Marie Denise Jolene, Hernandez Katrina Sobel, Leonardo Mary Louise, Magaway Rose Arcel, Marquez Bettina Isabel, Mendoza Maya Shelo, Rosario Patricia May, Santos Aloy Renz, Sobrepina Kim Angeli, Tech Natasha Kim, Urbano Mary Yasmin, Valdez Nikki Maxine, and Villanueva Mary Grace. I do hope and pray that those persons mentioned who made this criminal law reviewer will pass the bar exam, and hopefully I can see you guys in person to extend my thank you for making this criminal law reviewer. For those who would like to ask for a hard copy of this criminal law review, please ask the University of Santo Tomas, the Faculty of Civil Law, of how to get a copy, or ask their Team Bar Ops Academics Committee of 2016. I don't have any intention of copyright infringement, as I have said and written in the description box below that I made this audio lecture to help myself and my fellow bar candidates in reviewing the bar exam. My next audio reading will be the tax law review. Thank you so much for listening. I do hope I contributed something to help your criminal law review for the Philippine bar exam. I am doing this reading or audio to help also myself as I am struggling with my focus in reviewing the bar exam. I really find it hard to study, especially reading these notes, so I decided to make this video so that even if I am doing something or I am in public places, I still be reviewing the bar in my earphones. If you want also a copy of my reading audios, please send me a message, or if you want me to read some other bar reviewers in my email ad, sender5681@gmail.com, or to my Facebook page, sender5681. It would be a pleasure to help others while I am reviewing for the bar exam, and I am so happy to share these things to my fellow bar candidates. Thank you so much and God bless.